Hi, everyone. Thank you so much for joining me today, where we'll be talking about the top 3 ways to protect your assets with an estate plan. My name is Lynn St. Louis, and I am an estate planning and elder law attorney at ELG Estate Planning. And I'm so glad that you joined me today. If you have any questions, you can, and you're live on the Zoom webinar, feel free to put those in the chat. If you're on Facebook, we will be monitoring that and we'll put them in the chat. So I will try to answer all of your questions. So we're talking about protecting assets today, and we're talking about protecting assets through an estate plan. And what that means is we are not talking about the stock market today. If you are concerned because your investment portfolio isn't performing well, this is not the webinar that's going to give you any guidance on that. You will want to talk to your financial advisor. I am an estate planning lawyer. I am not a financial advisor. I don't offer financial advice. What I offer are fundamental principles that I think it's very important for everybody to understand so that they can implement those types of protections that legal documents can put into place for you so that you don't end up losing money or having your money go where you don't want it to go, all of those sorts of things. We're going to talk about that in detail today. Another thing that I want to point out is that I am licensed in Washington and Idaho, and that is what the jurisdictions that I'm going to be talking about. So if you happen to be listening to this later on down the road, maybe on our YouTube channel, and you are not in Washington or in Idaho, some of the things that I'm going to be talking about don't apply in your jurisdiction. Let me give you an example. I recently heard that TikTok is going to overcome YouTube as the biggest platform for social media. Now, if you have gone to TikTok, you know that it's really short bites of information. And that's not what we are going to be doing today. I'm going to be taking time because I think it's important to educate so that you can understand what these principles are. These are not things that you can just do in a really quick, never do this, always do this, never do this. Why? Because estate planning isn't about saying never or always. It's about understanding and putting the right plan in place for you, and the right plan in place for you depending on where you live. So if you live in Washington or in Idaho, you are very fortunate in that we have in our states a very simple probate process. It's what's called a non-intervention process. And what that means is that the court is not involved. And so everybody, if you've heard probate, you think, oh, that's terrible, I should avoid it. It depends. There are a lot of benefits that you only get through probate in the state of Washington, for example. You cannot get those benefits if you have a revocable living trust, for example. So if there could be people who are listening from other states, like California, for example, and they have heard, and they would be right, revocable living trust is the way to go in that jurisdiction. Absolutely. But that's not Washington. So I'm taking the time to help give you context that what we're going to be talking about today are the top 3 ways to protect your assets through estate plans, estate planning documents in the states of Washington and Idaho. Okay, let's go ahead and get started. To understand what are the most important ways to protect your assets, we have to talk about protect your assets from what? What are the biggest threats that you face? So let me identify those threats. I'm going to give you a list here. So a good estate plan is going to protect you from these threats: state intervention, state taxes, and liens. Estate taxes, long-term care costs, loss of government benefits, divorcing spouses of your beneficiaries getting the inheritance that you intended to go to your beneficiary and not that divorcing spouse, unintentional disinheritance. We'll talk about what that means, and creditors. So if you look at this list, admittedly, it does not involve how do I keep my portfolio from declining in the stock market. Like I said, that is for your financial advisor. But these threats are among the biggest threats that anyone faces, especially long-term care costs. Also, taxes and state liens and state intervention in your life. Those are expensive threats to you, to your assets, and to your family. And we're going to be talking about the three ways, the three top estate planning tools that will protect you. Number one, keep control of your affairs during your lifetime, no matter what happens to you. How do you do that? That is done through what is called durable powers of attorney. And you may have heard me talk about this before. You can live your whole life and never need a durable power of attorney, assuming that you keep your capacity, you don't suffer dementia, you never have a time in your life where you can't manage your own affairs. And if you're a lucky person that throughout your whole life, you never needed anybody to sign a legal document for you or to talk to your doctor for you or do anything on your behalf because you were cogent your whole life, you are a very fortunate person. As an estate planning and elder law attorney, what we talk with our clients about is the what ifs. Why? Because we all know that the what ifs happen. We sure hope it doesn't happen to you. But if it does happen, I want you to be protected. I do not want you to have something happen to you and there's nobody with legal authority to manage your affairs on your behalf. What is a general durable power of attorney? What that is that's a legal document you sign while you have capacity, while you're able to do so. And in that you say, if I can't manage my own affairs, I want, for example, my spouse to make sure that my spouse can handle all my affairs. That if we need to sell our house, my spouse can sign the legal document that allows us to sell our house. That if I am in the hospital and I can't talk to my doctors, my spouse can talk to my doctors. You see, what a general durable power of attorney, let's just remove general. What a durable power of attorney does is it allows you to designate somebody who can speak on your behalf if you can't. It's called the durable power of attorney because that document stays in place even if something happens to you and you no longer have capacity. That's the whole reason you want the durable power of attorney. Frankly, everybody wants to be in charge of their own affairs from now until the day they die. Nobody ever wants there to be the time when a durable power of attorney is needed. But we have to protect against that possible threat. So what is that threat? Well, the threat is you lose capacity. It could be a stroke. It could be some form of progressive dementia. These things are not that uncommon. And if that happens to you and you don't have a durable power of attorney in place, this is where the threat comes in. That threat is that the state takes over your affairs. The state, the court will call you a ward of the court, and everything in your life, your finances, your personal care plan, everything that has to do with you and what used to be you were in charge of, you're no longer in charge of because you can't be. You never did a durable power of attorney, so you didn't designate anybody else to speak with you. So by default, the state steps in and takes over your life. And I am not overstating it when I say it that way. They take over your life in that you are appointed as a guardian or a conservator to manage your financial affairs, to file with the court a care plan that says what goes on in your life. If you ever needed to sell your property, the court has to approve it. All of this is paid for by your own money. All of this is very public in that it's in the court, all of these details about your finances and your affairs. It's subject to the court supervision. And the person who's making the decisions that is approved by the court for the rest of your life, that could be somebody that you've never even met before. You don't know who they are. Granted, perhaps the court will appoint your spouse, or perhaps the court won't appoint your spouse. So this is a very intrusive invasion of your life. It's very costly. It's something that nobody would ever want to have happen if they could have prevented it. So this very costly threat can be avoided by having durable powers of attorney. You may have heard me say this before. These documents are the most important documents you can have. More important than your will, more important than a revocable living trust, more important than anything else that I can think of. So the durable power of attorney, having one will avoid any state involvement with your life and all of the costs that are associated with that. So that's the number one way that you can use an estate planning tool to protect your assets, is have durable powers of attorney in place. If you have any questions about durable powers of attorney, just pass them on and I will go ahead and answer them. Number 2, you can have estate planning documents in place that will avoid the necessity of you having to spend all of your assets on long-term care costs. Long-term care costs are probably the number one threat to anyone's financial security. Long-term care costs range from being in an adult family home that might cost $3,000, $4,000, $5,000 a month, to an assisted living, memory care, $6,000, $7,000 a month, to a nursing home of $10,000 to $12,000 per month plus. It doesn't take a whole lot of calculations to see that if you are facing long-term care costs of that magnitude, your savings might go away really quickly. And when I say savings, when I'm talking about your long-term care costs, I'm also talking about, let's say you're married. Maybe it's not you, but it's your spouse that needs to go into memory care or other type of care facility. How are you going to afford to pay for that? Most people do what I call the uninformed thing to do, and they spend down their money. They simply use their income, they use their life savings, and they spend their money. And they spend their money, and usually it's on the first spouse. Maybe the first spouse gets pretty good care because the couple used all of their money to take care of the first spouse, leaving the second spouse or surviving spouse with absolutely nothing. That is not necessary. Now, as an elder law attorney at Elder Law Group, we have expertise in Medicaid planning. And because of that, we know what type of legal documents must be in place to allow our clients to use government benefits to pay for their long-term care and not have to spend down their money. And we have other videos on this, but what I want to talk about is what sort of estate planning tool or tools do you need in place so that you don't become impoverished through long-term care costs, the number one threat to financial security. The primary tool that you need in place during your lifetime, again, is that durable power of attorney, the durable power of attorney for finances. So I've already explained what this document does. This document grants authority to somebody else to manage your affairs when you can't. So let's say you're either a single person or you're a married person. And let's say you're a single person and you are facing long-term care costs. you will want to grant authority to your decision maker, they're called your attorney in fact, to be able to take whatever actions that you would want to have taken to avoid spending down all your money. The durable powers of attorney that are prepared by an elder law attorney are different than those of an estate planning lawyer who doesn't know Medicaid. So for example, in our durable powers of attorney as elder law firm, what we will do is we will grant authority to do gifting that might actually impose a period of ineligibility under Medicaid's rules. An estate planning lawyer likely won't do that. They'll likely limit gifting to the annual exclusion amount of $16,000 under the federal tax code. I'm not talking about the tax code. Tax code right now is not what I'm worried about. I'm worried about Medicaid's rules. I'm worried about making sure your money doesn't all get spent down on long-term care costs. As a Medicaid planning lawyer, I know strategies that will allow you to gift money and preserve assets, potentially 50%, 75% of your estate. It all depends on what your situation is. But if I, as an attorney, am working with a client who's had a durable power of attorney prepared by somebody who doesn't know Medicaid, there might not be the grants of authority in there that are necessary to do a Medicaid plan. And as a result, our hands are pretty much tied, and we're not able to do the Medicaid planning that would be the optimal planning and save the most money. So the durable power of attorney and the authority contained in it is a critical piece to allow us to preserve assets for our clients. I was just talking about a single person. Let me talk about a married couple. So if you're part of a married couple and you're saying, Lynn is telling me I need durable powers of attorney to keep the court out of my business and to protect money against spend down from long-term care costs, you might be confused. You might say, I live in Washington or I live in Idaho, and this is community property jurisdictions here. And, you know, my spouse and I, we can make decisions for each other. Wrong. No, you can't. You think you can because it's a community property jurisdiction. So let me give you an example. Have you ever tried to call on your spouse's credit card and they said, I'm sorry, we can't talk to you. Can you put your spouse on the line and they'll give authority? I have. So has my husband. Have you ever been in a situation where you've tried to sell your home? Let's say the home is titled in your name and your spouse's name. And what's happened is your spouse now has lost capacity. They've suffered a stroke. They can't sign anymore. They're no longer able to comprehend things. Without a durable power of attorney, you can't sell your house. Even though your name's on the title and so is your spouse's name, it's community property, you can't sell your house. If you don't have a durable power of attorney, your spouse will be who's lost capacity under a court-ordered guardianship, and the court will give you authority to sell that house. Very frustrating. You think you can do it because it's community property, both your names are on it. Sorry, your spouse has lost legal capacity. They don't have a durable power of attorney. They're under a court-ordered guardianship. So don't think just because you're married, you don't need a durable power of attorney. You absolutely do need a durable power of attorney. How do we use a durable power of attorney to protect assets for spouses when you're both alive? Well, Medicaid has some rules that say that if one of the spouses needs long-term care, they can keep between $60,000 and about $135,000 accountable resources. That's it. There are a lot of excellent planning strategies for a married couple. One of them is called a Medicaid compliant annuity. If that couple has too much money, more than that standard, Medicaid allows the couple to take that extra money and buy a Medicaid compliant annuity. Let's say they have $200,000 too much. Not a problem from a Medicaid planning perspective. We will take that extra $200,000. We must put it in to the name of the well spouse. We must use the authority under the durable power of attorney, assuming ill spouse lacks capacity, to take all the assets, put them in the name of the well spouse, do a separate property agreement, How are we able to do that? If it wasn't done before the ill spouse lost capacity, we can do it through durable powers of attorney that we as elder law attorney draft and provide for our clients, because we know that these are the things that are needed to protect assets. So a couple who has worked with an elder law attorney is going to be able to keep perhaps not all their assets, but a significant amount of their assets, perhaps all their assets. It all depends on what their situation is. Well, what I'm saying is we can keep those assets. We can avoid spend down for that married couple, not just because we understand what the rules are, but because that couple has the right durable power of attorney in place that gives authority to do a separate property agreement, that has authority to revoke any prior community property agreement, that gives authority to transfer all assets, transfer the house to the well spouse. And by doing that, this couple can avail themselves of state benefits to pay for that long-term care without having to spend down their assets. Also, having these durable powers of attorney in place not only allows us to qualify the ill spouse for Medicaid without a spend down, but also allows us to avoid the state's lien. In the past, what I've talked about is sometimes maybe the couple is already within resource limits, and so the Helpful Nursing Home does a Medicaid application. That's a big problem, even if the benefits are granted. Why is it a big problem? Because the nursing home doesn't know how to avoid state liens. What has to happen, as I mentioned before, is the separate property agreement, the deed from the ill spouse to the well spouse, putting that property only in the name of the well spouse. Why? Because if the ill spouse is on Medicaid and on their death, any assets in their name will be subject to the state's lien. That's not going to be avoided if the nursing home did the Medicaid application and the couple didn't see an elder law attorney after that to fix it. With an elder law attorney, we are going to make sure that the state's lien is avoided by putting all assets in the name of the well spouse's name right when that ill spouse goes on to Medicaid. That way you can avoid the loss of the home or loss of any other assets that the state can get their hands on. So the two tools or the two ways to protect your assets I've talked about so far both involve durable powers of attorney. The first to avoid a court-ordered guardianship or conservatorship. Second, to avoid spend down. These are all accomplished through having a very good durable power of attorney in place prepared by an elder law attorney. Now, to back up a little bit, I mentioned that I'm in the state of Washington and Idaho. So if you're listening from another jurisdiction, please make sure you talk to an elder law attorney where you live in your state, because there are going to be different rules, different provisions the powers of attorney should have. If you're out of state and you're listening to this, I would recommend finding an elder law attorney in your state. You can go to the National Academy of Elder Law Attorneys.org. That's NAELA.org, NAELA.org. And there is an option to type in where are you located, where's your loved one located, and find an elder law attorney in your jurisdiction. Because I would be doing a disservice to you if you're listening from outside of the state of Washington or Idaho, and if you thought what I am telling you is 100% true for your state, because likely it is not. I also want to give you that caution because, like I mentioned earlier, let's say you're listening to somebody else. They have really good videos on YouTube, and they're really giving you a lot of good information on estate planning and elder law attorney, and that's fantastic. I'm glad that there are other attorneys helping to educate, because that's really what we want to see as estate planning and elder law attorneys. But if they are in a different jurisdiction, keep in mind that what they are saying might be completely wrong for where you live. So for example, and this is getting us to our third tool to protect assets. And what that is that's an asset protection will. I was listening to somebody on TikTok, and what he said is, never have a will, never go through probate, never do this. And it really struck me. How can a lawyer ever say always or never when it comes to the particular type of planning tool that's right for that client? Let me give you a little bit of background. So in Washington, as I mentioned, probates are really simple here. Do they cost money? Of course they cost money. Anytime you're working with a lawyer, it costs money. Unless you're getting free services from a pro bono program. But if you're dealing with an attorney in a law office, that does cost money, period. Is it worth the benefit? That's the question you need to ask. So in Washington, if we want to protect assets for a surviving spouse against long-term care costs, the only way we can do that is if we use a will with an asset protection trust. That means that will must be probated when the first spouse dies. And then all of the assets of the deceased spouse will fund this asset protection trust. All the money in that trust will not be counted by Medicaid in the state of Washington if the surviving spouse needs long-term care. So let me give you an example. Let's say a couple has $1 million. They have a house worth $500,000. They have $500,000 in other investable assets. One of the spouses has Alzheimer's, and they're what we call the ill spouse. They won't be able to live at home if the well spouse isn't there. And the well spouse has a heart attack and the well spouse dies. As part of doing their estate planning, we knew that we wanted to protect assets for the spouse with Alzheimer's. So we did a separate property agreement. We put 100% of the assets into the name of the otherwise healthy spouse, who then later on had a heart attack. So $1 million is what is the deceased spouse's share. $1 million is going to funnel through that person's will into the asset protection supplemental needs trust for the surviving spouse. Surviving spouse is going to have to move to a care facility. They can't live at home anymore. There is the house or the proceeds from the sale of the house in that trust. There's another $500,000. There's $1 million in this trust. And you know what? Medicaid says they look at it and they say, oh, we don't count any of those assets as belonging to the surviving spouse, the one who needs care. That's Washington's rule. That's why it's so critically important. If you are concerned about protecting assets for your spouse when you're gone against long-term care costs, a will is absolutely necessary. A will means there will be a probate. Yes, there's going to be costs associated with the probate. Let's say that probate costs $5,000, $10,000. Is it worth it to protect $1 million against required spend down? That's why in the state of Washington, a will with an asset protection trust is our best planning tool. If you are concerned about making sure you don't leave your spouse impoverished because of long-term care costs, then it's a will with an asset protection trust that I would recommend. If you've heard through other attorneys, through other videos, avoid probate at all costs, you're going to have to say, what are they talking about? At all costs? You mean you don't want to spend $5,000 to $10,000 for a probate to protect $1 million? That makes no sense. If you ever hear somebody say you absolutely must avoid probate, how? You do it through a revocable living trust. You should have a revocable living trust. You've got to ask more questions. So a revocable living trust, the whole idea with it is so that you don't have to go through a probate. So if you're not going through a probate, you have a revocable living trust. That's your setup. So with a revocable living trust, the whole idea is so that you can avoid a probate. All right, you live in Washington. You're that same couple that I just described. You know, one has Alzheimer's, One seems to be healthy. What happens when the one who has a heart attack dies? Well, guess what? All the assets belong to the surviving spouse. And so what if in their revocable living trust they set up a marital trust or some other kind of trust to hold the deceased spouse's share? Maybe they even tried to set it up as an asset protection trust. State of Washington will not honor that as an asset protection supplemental needs trust. That surviving spouse who now has $1 million and has Alzheimer's and needs care, all of that money is theirs. The state says zero, none of it is protected. All of it is going to have to be spent down before that person is eligible. So rather than protecting the entirety of this couple's estate by using a will-based estate planning platform, they were told avoid probate. So they followed that guidance and they set up a revocable living trust. Rather than protecting $1 million, they protected zero. It all needs to be spent down on long-term care costs. So when somebody tells you that you must avoid probate, you must have a revocable living trust, I would suggest that you ask questions. Well, why is that? Well, because you want to avoid probate. Okay, well, what are you trying to accomplish with your estate plan? You see, estate planning isn't about documents or you must have this or you must have that. It's about having an understanding of what your goals are. What are you trying to accomplish? Are you trying to protect assets against long-term care costs for your spouse? If so, I would likely recommend the will with the asset protection trust. On the other hand, if you have long-term care insurance or you have millions of dollars of assets, and let's say you have property in Oregon, Idaho, California, and Washington, I likely would recommend a revocable living trust route is the best way for you to go. And rather than focusing on, the long-term care cost issue, we're then focusing on avoiding estate tax in Oregon and in Washington. Washington, our estate tax is at $2.193 million. You can use a revocable living trust, or you can use a will platform to protect against unnecessary estate taxes imposed by any of the states that have an estate tax. Idaho does not. So protecting against estate taxes might be the goal of your estate plan. And it might be that you have property in multiple states. So a revocable living trust is the smart way to go. You don't want a probate in California. You don't want a probate in all of those jurisdictions. So yes, a revocable living trust is the right way to go. I can't answer the question, what is the right way for you in terms of what your estate plan is, but what I can tell you is that a good estate planning and elder law attorney is going to sit down with you, find out what your situation is, what your goals are, what are the threats to your estate plan. Is it long-term care costs, or is it paying unnecessary estate taxes? So all of those things are important to talk to your attorney about, the estate planning and the elder law attorney. If you have any concerns about long-term care costs, I would recommend that you are working not just with an estate planning lawyer, but with one that has elder law and Medicaid expertise, because that is a really focused area of practice that many people who do estate planning and do it very well wouldn't understand why certain provisions need to be included in a durable power of attorney, or why the will should be set up in a particular way, or why a revocable living trust should be avoided. Many estate planning practitioners in the state of Washington would not know what I just told you, which is that a revocable living trust will not protect assets for a surviving spouse against long-term care costs. So these are, they're worthy of having a discussion with your attorney. A couple of other threats that I haven't mentioned that these a will or a revocable living trust can protect you and your beneficiaries from is the unintentional disinheritance and creditors. Both wills and both revocable living trusts have the ability to make sure that creditors of your beneficiaries cannot get more than what they're entitled to, or we can actually defeat creditors' claims if they don't follow the appropriate mechanism that the law sets up to collect. So we can avoid certain creditors and having to pay them. Unintentional disinheritance, what that is when somebody is, let's say it's a couple, and they've been married 50 years and they've got 2 kids, and they both agree, of course, when we're both gone, we want our kids to get whatever, whatever's left. And then what happens is one dies, and then sometimes this happens at age 70 or 80, the person who's a surviving spouse remarries, and they fall in love, and they get in a new estate plan. And that new estate plan might be set up just like the couple's old estate plan was, which is everything goes to the surviving spouse. Well, if that's the situation, then the surviving spouse, let's say it's the person who's the new spouse, they're the survivor. What ends up happening is that the children from that first marriage, they end up getting nothing. That happens much more commonly with blended families. The way to avoid that is through setting up trusts for the surviving spouse so that they don't have the ability to redirect assets. That can be done through a will or through a revocable living trust. Again, as an estate planning lawyer, as elder law attorney, what we're thinking about are the what ifs. And so many times clients say, oh, I've never thought of that. Well, of course you haven't, and you shouldn't think about that. My job is to make sure I think about all these threats, all these things that might happen, so that your estate plan has all these protections in place so that you don't have to pay unnecessary estate taxes. We protect assets against long-term care costs. We make sure your beneficiaries get what you want them to get and not some new family. That we protect assets for your beneficiaries. Let's say one of your kids is on government benefits. We don't want to lose those. So we'll make sure their benefits go to an asset protection trust, just like the one that I described for the surviving spouse against long-term care costs. That kind of a trust is a discretionary trust. It's called a supplemental needs trust. What that means is that the government doesn't believe that those assets in there that are for the benefit of the person belong to the person, because they don't. And therefore, those assets don't interfere with government benefits. We can set up trusts for the beneficiaries to make sure that if there is a divorcing spouse of that beneficiary, they never get any of that money. It is protected against the divorcing spouse, against creditors, against any sort of threat that I can envision as an estate planning and elder law attorney. So there are very definite actions that can be taken to make sure that none of these possible threats will eat up your money, and either during your lifetime or once you are gone. How is that done? Primarily, it's done through meeting with an estate planning and elder law attorney with expertise in government benefits, including Medicaid, to make sure you have the right durable powers of attorney in place, and that you have either a will that will protect assets or a revocable living trust that doesn't protect assets for long-term care costs, but can be the right planning tool and also include provisions to protect assets against estate taxes. All right. So for those of you who are still with me, I wanted to let you know that we are going to be sending you a free guide to estate planning. It will have a lot of the information that I talked about, obviously not to the detail that we've been talking about. If you have any questions, feel free to go to our website. It's elgwa.com. You can send us an email, info@elgwa.com. You can call us 509-468-0551. If you are listening to this not live, but sometime in the future, and if this is on YouTube and you like it, please subscribe and indicate that you do like this information. Also, feel free to reach out to us if you want to know more something that I didn't touch upon today, but you would like to see us present more educational information about a topic that I haven't covered, just reach out to us, let us know. I think it's really important, especially for elder law, to try to get information to you so that you can share it with your family, with your friends, your loved ones. There's a ton of misinformation out there about long-term care, about elder law, about Medicaid. And my goal is to empower you so that you know what is the right plan for you and that you can empower others by sharing this information with them. So again, thank you so much for taking time and sharing that with me today. And if there's anything that we here can do at ELG Estate Planning, we'd be happy to assist you. Thanks so much for joining today. Take care.